Hello everyone, welcome back to Banking and Finance with Chitrak. Today we will be continuing with the second part of the fourth chapter of the anti-money laundering module, which is international guidelines and standards. So in the last chapter we discussed about the Financial Action Task Force. What is this? The work principle of the FATF, its composition, the standards of the FATF. Now today in this video we will start with the 40 recommendations of Financial Action Task Force. So let's begin. Now the first recommendation involves the anti-money laundering and countering financial terrorism policies and the coordination. So the first recommendation is assessing risks and applying a risk-based approach. Now countries must identify, assess and mitigate or reduce the money laundering and terrorist financing risks, and they should apply the RBA or risk-based approach to prevent the money laundering and terrorist financing, and requires financial institutions and designated non-financial businesses and professions, that is DNFPPs, to take action for money laundering and terrorism financing. The next recommendation is national cooperation and coordination. As you know, all the countries should have a national anti-money laundering and countering financial terrorism policies based on the risks identified, and need to ensure data protection and privacy and promote domestic interagency information sharing. The next two recommendations is about money laundering and confiscation. So what is money laundering offense? Countries should criminalize money laundering based on the Vienna Convention and Palermo Convention. It should be treated like a serious offense. Confiscation and provisional measures. Countries should adopt measures to freeze, seize and confiscate laundered property, instruments used for predicate offences, and properties used or intended for terrorist act, also corresponding value. So the next recommendations are about terrorist financing and financing of proliferation. So terrorist financing offense, countries should criminalize terrorist financing and financing of terrorist organization and individuals. The next, targeted financial sanctions related to terrorism and terrorist financing. Countries should implement targeted financial sanctions to comply with the United Nations Security Council resolutions. Then targeted financial sanctions related to proliferation. Countries should implement targeted financial sanctions related to weapons of mass destruction. Then non-profit organizations. Countries should review regulations to ensure they are not abused for financing terrorism. Non-profit organizations are vulnerable and should ensure they cannot be misused. Specific subset of NPOs to be subjected to supervision and monitoring. Next is preventive measures. So this recommendation is about financial institution secrecy laws. Now, it may happen that some financial institutions has their own secrecy laws by which they can deny giving confidential data to the authorities. Now, that should not happen. Countries should make the money laundering laws in a way so that it overrules the secrecy law of the financial institutions. So, the preventive measures has different parts. One of it is customer due diligence and record keeping. So we have discussed about customer due diligence previously, but again we are going through it. So financial institutions are prohibited from keeping anonymous accounts or accounts in obviously fictitious names. It requires to undertake customer due diligence for business relations or conducting a transaction above a threshold value. The customer due diligence measures include identifying customers, beneficial owner, understanding purpose or nature of the relationship, ongoing scrutiny of transactions, and effective control of money laundering and terrorist financing risk. If the customer due diligence is not possible from the customer's end, then the account must not be opened or any transactions shouldn't be performed, and terminate all relationship. And if there is already a relationship and then also the customer due diligence is not possible, then consider making a systematic transaction report. Then risk-based approach should be taken. The apply CDD measures using the RBA. Where unable to comply applicable requirements, then account must not be opened. Commence business relationship or perform transactions or terminate business relationship if CDD is not possible. Also, like I said, consider making a suspicious transaction report. This is applied to all the new and existing customers based on their individual risk. Then comes record keeping. All the transaction records should be kept for 5 years from the date. The customer due diligence record should be kept for 5 years after the end of relationship and date of occasional transactions. All necessary records should be maintained for at least 5 years for domestic and international transactions. Amounts and types of currencies and identity of the customer to prove the criminal activity should be kept. Keep all records obtained through the CDD measures, that is copies of the identity documents, business correspondence or analysis results, for 5 years after relationship ends or occasional transaction date. The next preventive measure is about additional measures for specific customers and activities. Now, some customers may be politically exposed persons, then the system should be there to determine whether he is a politically exposed person or not. Senior management should approve such relationships. One should ascertain the source of funds, and ongoing monitoring should be enhanced, and requirements for all types of PEPs also apply to their family members or close associates. Then correspondent banking related to cross-border or similar relationship. All the information should be gathered. Then the AML CFT control should be assessed. The approval should be from senior management. Understanding of respective responsibilities should be there. Then for payable through accounts, correspondent conducted CDD on customers with access to their accounts and able to provide CDD information on request. So payable through account is a type of bank account which allows a third party, mainly a foreign bank customer, to directly access and transact on the account held at a different financial institution. So it enables a foreign bank's customer to conduct banking activities in another country using the payable through accounts. Now, shell banks, prohibited from relationship with shell banks or shell companies. Also, the banks should satisfy themselves that respondent banks do not permit their accounts to be used by shell banks. Then MVT or money or value transfer services. MVT's providers are licensed or registered and subject to effective monitoring and ensuring compliance with FATF recommendations. MVTs or money value transfer services providers that use agents include them in the AML CFT programs and monitor them for compliance. So basically, any money or value transfer services should also be AML or CFT complied. New technologies. Assess MLTF risks pertaining to development of new businesses practices or new delivery mechanisms. Use of new developing technologies for both new and pre-existing products to be done prior to launch or use of new products or business practices and technology. Take measures to manage or mitigate those risks. So basically it's saying that when a bank is launching a new product, it should be properly identified having any money laundering or terrorist financing risks, so that after the launch of such products, the bank do not face such problems. Then wire transfer, which include required accurate or originator beneficiary information, and information should remain throughout the payment chain. Measures should be taken if detected without required originator or beneficiary information. Then it has freezing prohibitions, freezing action or prohibition on from conducting transaction with designated persons or entities. So if it is found that the wire transfer is for money laundering or terrorist financing purposes, the bank may prohibit any more transaction through that account, and they can also freeze such accounts. And this is done by the resolution 1267 of United Nations Security Council resolutions. The next part is about reliance, controls and financial groups. So reliance on third parties. The bank can rely on third parties for some customer due diligence, but the ultimate responsibility of the CDD is with the financial institution. What is the criteria? Immediately obtain necessary information, obtain copies of documents, third party regulated, supervised, monitored and considered information on country risk. Then it's about internal controls and foreign branches and subsidiaries. Implement programs against the money laundering and terrorist financing. Implement group wide programs against the MLTF, foreign branches or majority owned subsidiaries to apply AML CFT measures consistent with home country requirements. Then for higher risk countries, financial institutions to apply enhanced due diligence to business relationship and transactions with natural legal persons and financial institutions from countries for which this is called by the FATF. So now the next part is about reporting of suspicious transactions. So reporting of suspicious transactions, financial institutions to report to financial intelligence units if they suspect funds are proceeds of criminal activity or related to terrorist financing. Then tipping off and confidentiality. Financial institutions, directors, officers and employees should be protected from criminal and civil liability for breach of any restriction on disclosure of information in good faith to the FIU. Disclosing a suspicious transaction report or related information is prohibited. Then designated non-financial businesses and professions or DNFPBs. Customer due diligence. CDD and record keeping applies to also DNFPBs. They should apply group wide programs, DNFBs includes casinos, real estate agents, dealers in precious metals and stones, lawyers, notaries, legal professionals, accountants, trusts and company service providers. Other measure of DNFBs relevant to the regulation of foreign branches, obligations and measures against high risk. Then the next is about transparency and beneficial owner of legal persons and arrangement. So transparency and beneficial ownership of legal persons, measures to prevent misuse of legal persons for money laundering and terrorist financing, ensuring adequate, accurate and timely information on beneficial ownership and control. Then transparency and beneficial ownership of legal arrangements, measures to prevent misuse of legal arrangements for money laundering and terrorist financing, ensuring adequate, accurate and timely information of express trusts, including information on settlor, trustee and beneficiaries. Then power and responsibilities of competent authorities and other institutions. Regulation and supervision of FIs. FIs subject to adequate regulation and supervision and effectively implementing FATF recommendations. Even if they provide minimum services like money or value transfer or currency exchange, they should be licensed or registered. Then power of supervisors. Supervisors have adequate powers to supervise or monitor and ensure compliance with requirements to combat money laundering and terrorist financing. Next is regulation and supervision of DNFBPs. DNFBPs subject to regulatory and supervisory measures. Next, operation and law enforcement. Financial intelligence units or FIUs. Countries should establish a FIU which serves as a national center for receipt and analysis of suspicious transaction reports, other information related to money laundering and terrorist financing, and circulation of the results. Then responsibilities of law enforcement and investigative authorities. Countries ensure designated law enforcement authorities have responsibility of money laundering and CFT investigations within the framework of national AML CFT policies. Countries should ensure cooperative investigations with appropriate authorities. Powers of law enforcement and investigative authorities. Authorities should be able to obtain access to all necessary documents and information for investigations and prosecutions. This includes production of records held by financial institutions, DNFBPs and other natural or legal persons, search of persons and premises, taking witness statements and for seizure and obtaining evidence. Cash couriers. Countries should have measures in place to detect the physical cross-border transportation of currency and bearer of negotiable instruments, including through a declaration system or a disclosure system. Next is about general requirements. The statistics. Countries should maintain a comprehensive statistics on matters relevant to the effectiveness and efficiency of their AML CFT systems. Guidance and feedback. Competent authorities, supervisors, statutory bodies should establish guidelines and provide feedback. Sanctions. Countries should ensure there is a range of effective, proportionate and dissuasive sanctions available to deal with non-compliance. International cooperation. International instruments. Countries should take immediate steps to become party to and implement relevant international conventions. The relevant international conventions are the Vienna, Palermo, UN Convention Against Corruption, Terrorist Financing Convention. Mutual legal assistance. Countries should rapidly, constructively and effectively provide the widest possible range of mutual legal assistance in relation to money laundering and associated predicate offences and terrorist financing. Mutual legal assistance, freezing and confiscation. Countries should ensure they have the authority to take serious action in response to requests by foreign countries to identify, freeze or seize and confiscate property laundered proceeds from money laundering, predicate offences and terrorist financing, instrumentalities used for money laundering and terrorist financing or property for corresponding value. Extradition. Countries should constructively and effectively execute extradition requests in relation to money laundering or terrorist financing, that is arresting of people who has done money laundering and has fled away to different countries. Then other forms of international cooperation. Countries should ensure their competent authorities can rapidly, constructively and effectively provide the widest range of international cooperation in relation to money laundering and terrorist financing. Next, we'll discuss about the FATF's statement highlighting deficiency in the AML CFT systems in certain jurisdictions. FATF undertakes regular assessment of AML CFT regimes against the standards. It is able to identify international community highlighting weaknesses, and a list of FATF high and other monitored jurisdiction is maintained on the fatf.gafi.org website. So high risk and non-cooperative jurisdiction. How to identify? FATF identifies and engages with high risk and non-cooperative jurisdiction based on the review result of the International Cooperation Review Group or ICRG. It identifies jurisdiction with AML CFT deficiencies by 2 FATF public documents that is issued 3 times a year. Then the process, jurisdiction with strategic AML CFT deficiencies are identified and progress is reviewed periodically. Then, as you know, there are two lists provided by FATF, blacklist and grey list. Blacklist is jurisdiction subject to call for action, meaning they have a strategic deficiency in their AML CFT regime and need to apply countermeasures to protect the international financial system. As of June 2025, there are 3 countries in the list: North Korea, Iran and Myanmar. Then grey list, jurisdictions under increased monitoring, meaning they have committed to resolve swiftly identified strategic deficiencies within agreed time frames. As of June 2025, there are 13 countries on the list. Then how the progress is checked? Countries making progress are removed from the list. Those that don't address deficiencies may face countermeasures. Now, high risk sectors and activities. FATF has assessed vulnerability of specific sectors to money laundering and terrorist financing. Examples of sectors identified through studies are football sector, free trade zones, corruption, legal professionals, non-profit organizations and the diamond sector. Next, mutual evaluation of countries. FATF conducts mutual evaluations of various countries with the 4th round of evaluation results available in October 2013. Evaluation focuses on technical compliances and effectiveness. The ratings indicate how well a country has implemented the FATF recommendations: compliant, largely compliant, partially compliant or non-compliant. Then the ratings indicate a country's level of effectiveness on each of the 11 immediate outcomes ranging from high to low level of effectiveness. Now, what are the 11 immediate outcomes? Those are undermining the profitability of the crime, the ability to identify, trace and confiscate criminal proceeds. These include both conviction and non-conviction based confiscation. Effective supervision, ensuring financial institutions and other designated businesses are effectively supervised or compliance with AML CFT requirements. Then financial intelligence, a robust and effective financial intelligence unit is crucial for gathering, analyzing and disseminating financial intelligence related to money laundering and terrorist financing. Criminalization of money laundering. Laws are in place to criminalize money laundering and ensure that those involved in laundering the proceeds of crime are held accountable. Then criminalization of terrorist financing. Laws are in place to criminalize the financing of terrorism and related activities. Preventive measures for financial institutions. Financial institutions effectively implement preventive measures to deter and detect money laundering and terrorist financing. Preventive measures for designated non-financial business and professions or DNFPBs. DNFPBs like lawyers, accountants, etc. also have effective preventive measures in place. Transparency and beneficial ownership. The transparency of legal persons and arrangements like companies and trusts is ensured. Beneficial ownership information is accessible to relevant authorities. International cooperation. Effective international cooperation is in place to combat cross-border money laundering and terrorist financing. Then terrorist financing investigation and prosecution. Individuals and groups involved in providing financial support to terrorism activities are investigated and prosecuted. And last, proliferation, financing sanctions. Actions are taken to prevent the financing of the proliferation of weapons of mass destruction. What are the key goals? Each of the 11 immediate outcomes represents a key goal that an effective AML CFT system should have. The assessment looks at how countries interact and whether they achieve the expected results, providing a process to ensure countries take measure to address weakness. Now we'll discuss about FATF style regional bodies or FSRBs. FSRBs are international bodies for AML CFT standards, sharing the objectives and diverse complexities of FATF. They operate on regional level, helping members implement the FATF standards and supporting FATF's effort. First, we have Asia Pacific Group on Money Laundering or APG, intergovernmental organizations formed in February 1997 in Bangkok, composed of 41 members jurisdictions regionally focused within Asia Pacific and a number of international and regional observers. The purpose is to promote adoption, implementation and enforcement of internationally accepted AML CFT financing standards set out in FATF recommendations. Next we have Caribbean Financial Action Task Force or CFATF. It's an organization with 24 countries and it's of the Caribbean basin. It was established in May 1990 and is representative by Caribbean and Central American and identified 19 issues specific to the region which were adopted in November 1992. This issues public statement on jurisdiction reviewed for measures taken to address deficiencies. Then we have Council of Europe Committee of Experts on the Evaluation of Anti-Money Laundering Measures and the Financing of Terrorism or MONEYVAL. It's a monitoring body of the Council of Europe. Its task is to assess compliance with international standards in counter money laundering and terrorist financing and the effectiveness of their implementation, as well as making recommendations for national improvements. There's also an important group called Eurasian Group or EAG. Its FATF style regional body comprises of Belarus, China, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, Turkmenistan and Uzbekistan. It comprises of 15 member countries and 23 international and regional organizations as observers. The purpose is to ensure appropriate legal and institutional framework combating money laundering and terrorist financing in line with FATF standard. Then there is Eastern and Southern Africa Anti-Money Laundering Group or ESAA AMLG. It was established in 1999 of August. It has 19 members. It has regional and international observers and carries out mutual evaluation. Then Financial Action Task Force of Latin America or GAFISUD. It was established in December 2000. It has 17 members and 6 states and 9 organizations as observers. Then there is Governmental Action Group Against Money Laundering in West Africa or GIABA. It's Institution of Economic Community of West African States or ECOWAS. It's responsible for facilitating the adoption and implementation of AML safety in West Africa. It's an FATF-style regional body working with 16 member states to ensure compliance with international AML safety standards. Middle East and North Africa Financial Action Task Force or MENA FATF. It was established in November 2004 and has 21 member states, 6 states and 11 organizations as observers. Then we have Task Force on Money Laundering in Central Africa or GABAC. It is Economic and Monetary Community of Central Africa, established in 2000, recognized as FSRB in 2015. Its objective is to assess compliance of its member against the FATF standards, providing technical assistance and facilitating international cooperation. It has 7 countries and 4 organizations as members and 3 organizations as observers. Then there is Group of International Finance Center Supervisors or GIFCS, formerly called Offshore Group of Banking Supervisors. It was established in 1990. It was established in October 1980. Its objective is to cooperate with relevant international organizations in setting and promoting the implementation of international standards for cross-border banking supervision and combating money laundering and terrorist financing. It has expanded its coverage to regulation of trust and company services providers, and more recently they also regulate hedge funds. It has observer status with the FATF and BCBS. Next, there is an important group called the Wolfsberg Group. It's an association of 13 global banks, and the banks that it has are Banco Santander, Bank of America, Barclays, Citigroup, Credit Suisse, Deutsche Bank, Goldman Sachs, HSBC, JP Morgan, MUFG, Societe Generale, Standard Chartered Bank and UBS. Its objective is to develop frameworks and guidance for the management of financial crime risks. It started in 2000, primarily working on AML guidelines for private banks, but has expanded to all aspects of AML KYC practices and financial crime prevention. The key guidelines issued by the Wolfsberg Group are Wolfsberg Tax Evasion Guideline, Wolfsberg the Trade Finance Principles, Screening Guidance, Payment Transparency Standard, Anti-Bribery and Corruption Guidance, PEP Guidance, Public Statement on PEPs, Swift Relationship Management Application, Due Diligence Guidance, Anti-Money Laundering Principles for Correspondent Banking, Mobile and Internet Payment Service Guide, Private Banking Principle, Prepaid and Stored Value Cards Guidance, Credit Card Guidance, Statement on Payment Message Standard, Notification of Correspondent Bank, RBI Guidance, and Wolfsberg Group Statement on Suppression of the Financing of Terrorism 2002. So that was it for this chapter. I hope it was helpful to you, and there's an exam on 23rd and I'm trying my best to upload as many chapters as possible. So keep following, keep sharing, and if you have any query, do comment below. Thank you. All the best. Keep studying.